here this morning to hear oral arguments in the case of Brimer versus Kichner. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded and posted online, so please try to remain behind the podium as much as possible. If you intend to refer to a child during your argument, we'd ask that you use that person's initials instead of their name, because we do post these arguments online. So in the interest of security and privacy, we ask you to use the child's initials. We have read your briefs and we're ready to proceed when you are. We do use the front podium up here as well. So, Mr. Brimer? Is it Brimer?
Yes, thank you.
Thank you. Would you like to reserve any time, sir?
Yes, I think so. I'm pretty quick, I
Up to
think.
5 minutes. How much do you want to?
5 minutes would be fine. Thank you. Good morning. I'm here today because I believe that the trial court reached a verdict, I guess, in my case that was incorrect based on evidence that wasn't presented and procedures that weren't followed by both attorneys and the guardian ad litem. So I've just prepared a short statement. Our child recently turned 5. She was only a year and a half old when we started this process. There really are no winners here. Everyone loses, and the children lose the most. Isabel's mom, Heather, is not a bad person. I don't want to disparage her. She just has some issues that prevent her from being an effective parent sometimes. In the years that I lived with her, I found that her good days were often great, but her bad days could be really, really bad. When I met her, she was apparently well-regulated. Medication was around 6 months into our relationship, she became pregnant and had to quit her medication cold turkey. She turned into a different person than I initially known and loved. I know that she was under the care of a psychiatrist because I used to drop her off at the appointments, and I also picked up her prescriptions from Giant Eagle. She told me that her doctor thought that she was bipolar, and he prescribed her lithium. When I say that sometimes she's has trouble being an effective parent, I mean that when I met her, her house was really just a disaster, full of garbage.
Counsel, I'm sorry. I'm used to saying counsel, Mr. Brimer. I just want to make sure, as a judge, that I indicate to you that the only thing you're really allowed to talk to us about are things that are actually in the record. And by the record, I mean evidence that was submitted to the court that the court considered. So I just want to have that caveat with you, give you that little instruction, so that we can't consider it. So especially since it's being broadcast and everything, I just want to make sure you stick to what's actually presented at the trial court level.
Okay. I'll skip forward to...
If it was presented, it's fine. I'm just saying if it wasn't presented, then you can't get into it.
Oh, yes, everything that I've said today is was spoken about at length during the...
Let me ask you a question.
Yes, of course.
Attorney DeRay states that there was no transcript filed with this, with your brief.
I received a letter saying that it was.
There was a transcript that was filed
Yes,
subsequent. So everything you're speaking about is in that transcript, and we have the ability to take a look at the trial court itself.
As far as I know, yes, absolutely. Absolutely. I believe it was some 400 pages or something. Okay. I also spoke at the initial proceeding about the fact that she had many animals living in the home, 7 dogs, at least 8 cats, and a lizard and some rodents. I'll get on to, I believe that I had my representation, my legal representation was severely lacking. I had 2 attorneys.
No, I don't think you raised that on your appeal, did you?
I believe I did.
I don't see ineffective assistance of counsel as one of the issues. Is anybody else seeing that as an issue?
This was hard for us, I'm gonna be honest with you, at least for me, I can speak for myself, Mr. Brimer, because usually the parties that appear in front of us have to actually lay out assignments of error and say, the trial court erred in this manner, or my counsel was ineffective for doing this. So you didn't really do it that way. I know you complained in your brief that you didn't think your attorney adequately advocated for you, is that right?
Yes, absolutely. I thought perhaps I would have some time to elaborate on that further here. I was trying to keep the brief. I know it's supposed to be a certain number of pages and not too long.
Well, I think your main argument was you just didn't feel like you got a fair shot, right, by anybody? The court, your attorney, anybody that was involved.
The
in
GALs
proceeding.
in particular.
The GAL, everybody.
There were two. The first one was completely inactive for 20 months or something, just by calling him. At one point I was calling every day for 6 months. I was here at the courthouse. I live near Detroit, and I came down, just pleading, who's the GAL accountable to, you know? Who can I talk to about his inactivity? My attorney refused to fire him, and eventually.
Did your attorney hire the guardian ad litem? The court appoint a guardian ad litem?
The court appointed it, yeah.
Yeah, but then the attorney couldn't fire the guardian.
Okay, I guess I was pushing for him to get him removed because of his inactivity, or
So the attorney didn't file any motions having removed.
he flat out refused to. It was suggested that I should fire my attorney and seek new counsel.
Was this someone that you hired, or was this person appointed by the court?
This attorney I hired, yes, he was hired and retained by me. I'm sorry, you're speaking about my personal attorney or the GAL? My personal attorney, okay. I'm sorry for the confusion. So there's a list of things that the GALs are supposed to do during the case. And naturally, the first GAL made no attempt to do anything at all, despite reaching out to him constantly. Well, at first I was just calling him once or twice a week, but eventually got to the point where I was calling every day. So the second GAL, she at least made an attempt, but there were several points that she didn't follow up on. She failed to request mental health assessments for some of the people that were living in the home with our child, the minor in question. She failed to interview school personnel and medical and mental health providers and obtain copies of those records. Both of the other children mentioned were hospitalized for breathing problems, which I believe are directly related to the living conditions in the home. And she failed to write a written report. I was handed a document the day that we were supposed to go to trial and said, here, sign this. It's going to save you some money. I'm not going to prepare a written report. And I said, what do you mean? And she said, well, it's time consuming. It'll take me 5 hours and it's going to cost you this much money. And it would be easier if you don't. And I'm thinking, well, here we are at the trial. What do you mean you haven't done your job? And then I'm almost done here. So our case wasn't on the docket at all the morning of the trial. I looked in the lobby on the TV and I'm thinking, what's going on here? Here had been going on now for something 22 months. So it was apparent to me that they were going to try and convince me to settle this case without going to trial, which I had already said, very unlikely they were going to be able to reach a settlement because the main sticking point was where the child was going to live. I should also note that I had asked my attorney, especially the first one, we wanted joint custody. He insisted on going for full custody because he figured we could use it as a bargaining chip later, which I told the secretary.
Oh, it's a bargaining chip?
He said, oh, yeah, it's a bargaining chip. We want to have a strong position. And, I wish that had never happened. I never wanted full custody ever. And I told the GAL that, and I said, can you do something? Both my attorneys refused to change that. I don't know if it was a lot of work for them or what, but.
Did you ever attempt mediation?
No. I'm not sure what that is. that was never presented as an option. So my attorney in the GAL and one in the trial, the new attorney and the new GAL, who've been on the case, both of them for around 2 months or so at that point in time, they tried to convince me to settle. They did kind of a good cop, bad cop thing. They said, look, you're not going to get what you want at trial. This is the only option for you. The judge has already made up his mind in this case. You're not going to like the outcome. And this went on for the entire morning and after lunch before finally I said, look.
But I want to warn you, one of the problems, I think, with what you're arguing is there's probably not going to be anything that we can review to see any of that, right? Because what you're saying is these were all conversations probably in other rooms and in the hallway, all those type of things, right?
Yes, they pulled me into a conference room.
That's what I'm saying. So you see, the problem we have with those type of arguments is we don't have anything to verify it.
Sure. There was another party present. My mother was in the room as well.
That's all stuff that should have been presented at trial, and there's no record or recordings of anything that were put on the record at the trial, but we have no ability to look at any of that stuff.
Okay. So I should have forced my attorney to bring up the fact that he tried to rope me into taking a settlement or something, or I'm not sure how I.
It's a difficult position. We understand that, but we're just,
Oh, I
it's
understand.
difficult for us too, because then I'm just trying to explain to you, because being pro se, it's hard sometimes to understand the way things work. And I want you to know the process here.
We have 4.5 minutes left, if you want to save it till after he's done.
Okay. Yeah, I just have a tiny bit more, but I can come back into the end.
If you want to, be free to use whatever time.
Oh, the only other thing that I wrote on here was when I got into the courtroom, the presiding judge, off the record, I don't believe the stenographers in the room, and this is also not going to be on the record because, but he was very sternly, look, you need to just take the settlement. You're not going to like the verdict here. You're not going to like the child support you have to pay. You're not going to like any of this. And he made everybody leave the room except for me and the other party and said, take the settlement. And I thought, well, geez, and the judge's supposed to be impartial, at least a little bit, maybe hear my, or see that it's presented. So I was forced to pay most of the GL costs and the court costs. My child support is calculated an inflated number of working hours, and basically sole custody was given to my ex. I think that was kind of punitive. I think those were punitive measures. Thank you.
May it please the court. My name is Steve DeRay. I represent the mother in this case, the mother of IB. I would just ask this court to consider looking at the decision that the actual trial court did do, and the very concept of the trial court not doing its job is beyond absurd, and it's an absurd statement for him to even make. This trial took 3 days. This is a 40-something page decision, 45-page decision that spells out every fact and every detail on this case. Mr. Brimer to come up here now and talk about the fact of him wanting shared parenting, I think he left out a major important part, which again won't be on any record, but that the whole point of the discussion was about trying to get him to agree to a shared parenting plan, and it was his insistence on wanting sole custody going forward. And the idea of him coming in and saying that it was his lawyer's tactic.
Counsel, you know as an attorney practicing that I don't have to tell you.
I know. I'm just answering stuff that I know.
Well, I understand, but we can't consider anything that he says is not in the record.
I understand.
So we can't
So,
consider yours either.
The simple idea being that if you look at the length and the efforts that the court made in doing the decision, there can be no doubt how active this court was of trying to get this decision done, as noted by the fact that there were 3 days of trial set aside. And those 3 days of trial were really us waiting for Mr. Brimer in terms of what he was doing in the case that he was presented. When we get to the actual what he appealed, I had an extraordinary amount of difficulty as well trying to determine, and so if you notice in my brief, I tried to break down the page that had the assignment of errors, and I will not say that mine is scientific. I just took what was on the assignment of errors page and broke it down into 7 different assignments of error that I saw. The first one of that was allowing the case to drag out almost indefinitely. Your Honors, that did not happen. This case pended from January of one year till September of the following year. Ordinarily, the case should be about a year and a half, but we had one problem. That is, the first guardian ad litem was slow getting involved in the case, did an investigation, and then subsequently ended up and is currently still in jail to this day. Attorney Jim Patterson. So we were not in a position at that moment of time of going forward. We ended up getting guardian ad litem Stephanie Pinsky. Stephanie Pinsky came in and frankly did a yeoman's effort of trying to get the analysis taken care of. In terms of that, there's the reference that he made to the guardian ad litem not doing her job. I would ask the court that if you look in my brief, I spelled out, and it is spelled out in the decision of the court, exactly what this guardian ad litem did. This guardian ad litem drove all the way to his home in Michigan to do a home visit. She talked to I believe she talked to everybody that she had been given the name and the information for. She also talked to Lorain County Children and Family Services, was able to review their entire file, which Mr. Brimer was trying to indicate would be something that would be helpful to his case or not. She helped organize parenting time, and she made recommendations. In terms of his statement about her not filing a report, he's mistaken. On August 13th, prior to trial, there was an agreed entry entered into that waived the requirement for her to do a written finding because, in fact, she had told everybody that at a pretrial in hopes of trying to get the case resolved. For her, it seemed to be a rather simple case. So in terms of the assignment of error, which I believe the second one with respect to the guardian ad litem and the first one of the case being dragged out almost indefinitely, I would encourage this court to suggest that that is not the case at all, and it's pretty easy to see just by looking at the court's decision in the docket. He indicated the court erred by not taking the case seriously. I don't know what else I don't have a legal response to that. I think my only response is for the court to go through and draft a 45-page decision. I think that would mean that the court very, very much took this case extraordinarily seriously. The fourth assignment of error was the trial court granting an unnatural bias to appellee. I still don't know what exactly that particularly means. I don't think he raised anything like a tender years doctrine or something from back in the 90s when that was in the statute. That's not in the statute. That's not what the court was considering at all. The fifth one, I don't know. It says the trial court erred by encouraging settlement. I've been doing this for 20 years. If you did not have your juvenile courts and domestic relations courts actively trying to urge people to settle, that really undercuts the very idea of what we want to do when we parent our children. The idea that we got a guardian ad litem involved in for him to just not listen to, for him to go through counsel not to listen to anybody, for the court to try and provide some directive based off of a lot of information that had been presented, and for him just to ignore that and then to say, well, the court never even should have tried to encourage settlement, yet to stand up here and say, but I wanted a shared parenting plan, but this was leverage for this, that, the other. These are all the moving parts and confusion of why we ended up with 3 days of trial. We ended up with 3 days of trial because of the man sitting behind me, about the man that couldn't make the decision in terms of what needs to be done, wouldn't listen to anybody about it, and couldn't achieve the best interest of his daughter. Nowhere in there does he actually present one thing in his brief that says how he could have custody of his daughter. Here's a guy who is living at home, who had never actually had a full-time job, right? Had, I think, one full-time job in his entire career, making under $10 an hour and wanting to have custody. They put their child, and it's in the record, in child care while he was down here not even working. And yet he comes in to say, I wasn't treated fairly. I will end it by saying, if you just read the findings of the court, every one of these arguments where he says he wasn't listened to, oh, he was listened to. And the court finally concluding, after listening to him, had no choice but to make a determination that it was impossible to have a shared parenting plan in this situation. Nothing further.
Mr. Brimer, you have 3 minutes and 15 seconds left, sir.
We did only very technically, we have 3 days of trial. The first day, I was here at 7:30 or so, and we didn't actually start doing anything until around 2. So counting that hour as a day of trial, I don't think that's a very good representation of what actually happened. The other days were quite similar. The trial didn't last for 3 full days at all. The GAL didn't follow up with a lot of the points that I made when she was at my house visiting. She asked if I had any concerns about someone's mental health, and I said, well, both my mother and I said, hey, her older sister, there are some real concerns there. I've watched her viciously attack the younger brother, and that was something that we definitely wanted brought up. Her safety is a great importance. Also, the mother has a history of self-harm, and apparently the oldest child witnessed that on at least one occasion. And when I brought that up to the GAL, I said, I think that's just attention-seeking behavior. I don't know that she would hurt the child. And she said, sometimes people hurt children in order to get attention. And I said, I never even considered that. That's something that I really want to look into as well. I appreciate you at least hearing my case.
Thank you for your presentations today. The court will take the matter under advisement and issue a decision, which will be mailed to both sides as well as posted to our website and added to the Supreme Court.
Thank you, Your Honors.
With that, court is adjourned.